Good morning and good evening. Good morning in Europe, in Czech Republic, and as well good evening in Fiji, in South Pacific. My name is Aurélien Orange, and together with my colleague Anna Maria Blanova from the Coax Foundation, we'll organize this match counting for the Hague Inter-University Law Debate Tournament 2024. I give the floor to my colleague.
Thank you very much. And indeed, good morning and good evening to the students. And hello and welcome to everyone joining us online. So today marks the one of the final matches in the round 2 of the Hague Inter-University Law Debate Tournament of 2024. The students have prepared for 7 days for the topic, International Arbitration Undermines State Sovereignty Favoring Corporate Interests in Dispute Resolution. So the teams have prepared for positions in favor and against. In a short while, we'll find out which team will defend which position during the debate. But before we do that, it's time to learn a bit more about our participants today, starting with the University of South Pacific, Fiji, Mr. Parmal. The floor is yours.
Hi, Bola, everyone from Fiji. It's an honor being here again and competing with Masaryk University. Looking forward to the debate. Thank you.
Thank you very much. Now, moving to Brno, Mr. Chura.
Hi, I'm Marian. It's an honor to participate in this competition, and good luck to everyone.
Thank you and welcome. Moving on to Suva, Ms. Prakash.
Greetings to everyone. My name is Vishal Prakash, and I'm very excited to be here with all of you. And with that, good luck to everyone.
Thank you. Welcome. Ms. Palyarikova in Brno.
Hello, everyone. My name is Martina Palyarikova, and it is really honor for me to participate in this event. So good luck to everyone and enjoy it.
Thank you and welcome. From Suva, Ms. Lal.
Hello everyone, I'm Kaya. I'm a third year student with USP and also super excited to be here. All the best everyone.
Thank you and welcome. The two teams are also supported by their mentors. University of South Pacific is supported by their coaches Ms. Diana Burishova and Mr. Peter Pranish. Masaryk University also has their coach present on the call today, Professor Schwetz. If you would like to give a few words to students.
Good morning and good evening. It's always a pleasure for the Masaryk University to be part of this wonderful competition. This is our second year, and we are even more excited than 1 year ago. So good luck and enjoy it.
Thank you. And indeed, good luck to the students. In a short second, you will see my screen for the allocation of your positions. If you can just give me a confirmation that you can see it.
Yes.
Thank you. All right. So without further ado, all right. So for today's debate, it will be the Masaryk University that will argue for the position against. So to clarify and to confirm, the University of South Pacific Fiji will argue for international arbitration, undermining the state sovereignty, favoring corporate interest in dispute resolution, whereas Masaryk University's debaters will argue that international arbitration does not undermine state sovereignty, not favoring corporate interest in dispute resolution. You will now have 5 minutes to finalize your preparations, and once the timer is up, we will start with the team in favor, therefore the University of South Pacific. Feel free to close your cameras and review your notes. All right. Thank you, everyone. The time for final preparation is now over. We'll be starting with the position in favor. The debating team of University of South Pacific, you have 4 minutes for your opening statement.
May I confirm that I'm audible, please?
Yes, you are.
Thank you. Greetings to the honorable judges, colleagues, and audience members. Today, we affirm that international arbitration undermines state sovereignty, favors corporate interests in dispute resolution. We will advocate for our stance through the following arguments. I will argue that fair and equitable treatment, FET, clauses are vague. Secondly, that arbitration can give rise to regulatory chill, undermining state sovereignty. Varunesh will then discuss the costs and protracted nature of arbitration before Visha argues that expropriation is employed by corporations to favor their interests. FET clauses are included in agreements such as bilateral investment treaties, or BITs, to ensure equality between parties and to protect investor interests. Despite it being part of many BITs, FET standards remain vague and open to the interpretation of the arbitrator. This ambiguity can be problematic as the clause can be interpreted differently by stakeholders. Due to this clausal uncertainty, commercial affairs can be seen to be beneficial over state and public interests. The following arbitration cases demonstrate this. In Crystalex and Venezuela, Crystalex was denied mining permits due to a breach of Venezuelan environmental regulations. The tribunal then ruled in favor of the company impeding state sovereignty, despite regulations being implemented to help protect Venezuela's culture and environment. Similarly, in the 2015 case of Bilkin in Canada, Bilkin's quarry development project was rejected by a review panel in Canada due to its negative impact on the environment and community core values. When the case was brought to a tribunal, arbitrators interpreted this decision as a breach of FET and impeding the legitimate expectations of investors. Here, the tribunal failed to consider arguments relating to environmental and Canada's public policy concerns, demonstrating the prioritization of corporate affairs. Imposing state sovereignty through international arbitration can also give rise to regulatory chill, which is applicable when states reconsider the enactment of beneficial legislation, fearing arbitral legal action. This reflects that adverse impact international arbitration can have on the sovereignty of states in introducing legislation applicable and beneficial for its citizens. For instance, following the onset of the legal actions by global tobacco giant Philip Morris, other tobacco corporations also threatened legal actions against Uganda and Togo for their public health policies. Two countries hesitated to implement policies that would benefit the health of their people because it would affect the profits of an international company. Let that sink in. Further, regulatory chill can impact the sovereignty of low to middle income countries as they may fear being unable to fund potential legal actions, preventing them from enacting beneficial legislation. If cases do reach a tribunal, they may feel the need to settle. Uruguay, prior to their case with Philip Morris, stated that if a sympathetic international party had not funded their case, they would have had no other choice but to give in and settle. These examples show that approaches by international arbitration tribunals that often favor corporate interests can and do have a significant impact on how a state legislates because they fail to consider environmental and public concerns. Is this really worth it? My team will continue to argue that it is not. Thank you.
Thank you very much. We will now hear the opening statement in the position against. Debating team of Masaryk University, you have 4 minutes.
Thank you for the word. Dear judges, dear colleagues, allow me to introduce you to our stance on this topic. And as the thesis is revolving around state sovereignty, we should establish what we imagine under this term. State sovereignty is an ability to enforce its own laws in its own territory and freedom to control its affairs without other countries' intervention. However, thanks to the existence of international law or international organizations, such as EU, the sovereignty is no longer an absolute term, as states are willingly bound to comply with law and rules of given organization. As all of us can very well perceive, we are living in a fast-paced and dynamic world. Moreover, countries and also we as individuals are part of international system. This system is characterized by an economic interdependency, and therefore we meet problems that need flexible and fair response. For this reason, international arbitration stepped in the game. The process of international arbitration and the choice of arbiters requires an agreement of the parties, which is given via an arbitration clause inserted into the contract. Nowadays, we have this mechanism that is recognized and enforceable in over 150 countries under the New York Convention. And country, as a sovereign actor in interdependent international system, willingly decides whether it wants to be a signatory or to be bound to fulfill its obligations. Certainly, as the beginning of the international arbitration history that didn't count on challenges we are facing now, such as COVID-19, there were pitfalls in the mechanisms. However, in 2020, UNCTAD introduced a document reforming international investment arbitration, which introduces new tools for protecting states and mainly social interests. We argue that thanks to the reform, state sovereignty strengthened. States may include a denial of benefits clause that would allow denying protection to some entities, for example, investments that are owned or controlled by persons from countries which the denying party doesn't maintain diplomatic relation or which are subject to economic sanctions. Secondly, reforms brought explicit acknowledgement of the right to regulate, which allows states to regulate private investments in order to protect public interest. Instances of public interest as health and safety include preservation of the environment or public morals. Lastly, measure that strengthens state sovereignty is incorporation of public policy exceptions into the contracts, which can significantly help the state to be able dynamically and swiftly react to economic and social challenges without a threat of facing the international investment arbitration. Remaining sovereignty during the international arbitration process is our argument. Also, we argue that states further strengthen its sovereignty thanks to these reforms. Thank you.
Thank you. We have now heard opening statements from both teams. We are now proceeding to the rebuttals, starting with the position in favor. You have 2 minutes.
Distinguished teams, judges, and audiences, I commend my colleagues in the opposing team for presenting their views. However, my team disagree with the stance that state sovereignty is not undermined in favor of corporate interests in international arbitration. To rebut their assertion, I would like to raise the inherent power asymmetry between states and corporation, which tilts the balance in favor of corporate interests, thus eroding state sovereignty in terms of resources. International arbitration invariably imposes substantial financial burdens on a state, particularly nations with limited resources, given that arbitration proceedings can entail substantial costs. Take, for example, the protracted legal battles in cases like Philip Morris versus Australia and Philip Morris versus Uruguay, which took 6 years to be arbitrated. Although both outcomes favored the state, Uruguay, prior to their case with Philip Morris, stated that if an international party had not funded their case, there would have been no choice but to settle. The duration of these proceedings underscores the exhaustive nature of international arbitration on state resources. This challenge is even more pronounced when contrasted with the financial resources of international corporations. These corporations are endowed with superior financial resources and legal acumen, and are better positioned to leverage international arbitration as a tool to contest and undermine state regulations. In essence, the resource-intensive nature of international arbitration underscores the propensity to disadvantage states over corporations, effectively compromising state sovereignty, tilting the scales in favor of corporate interests. Thank you.
Thank you. Now for the position against, you have 2 minutes for your first rebuttal.
Thank you. I just want to make sure that I'm heard.
Yes, you are.
Okay. We completely or almost completely disagree with this statement. State is keeping the sovereignty when they enter these international investment agreements. As was already pointed out, these agreements are voluntary, and all these clauses are agreed upon by the state. Arbitration is a flexible, reliable, and a neutral way how to settle disputes between investors and countries. We just want to point out that countries have option to choose one arbitrator themselves, and the arbitrator will choose will have to agree upon another arbitrator. That means that countries can directly have influence over 2 out of 3 arbitrators. These arbitrators they can choose, and they choose, are experts in the respected industries, and they understand the topic very well. Moreover, as was already explained, this system is supported by more than 150 countries, which further gives it credibility. And as was already said, the view and the perception of sovereignty has evolved. States are giving sovereignty away, which is not the same as undermining the sovereignty in exchange for membership in international organizations. There is also another way in which states keep most of their sovereignty. For example, North Korea. But I think it speaks volume when we say that North Korea is not an example we want to follow. Thank you.
Thank you. We'll now hear the second rebuttal in position of favor. University of South Pacific debate team, you have 2 minutes.
Just to confirm that I'm audible and visual.
Yes, you are.
Before I begin, I would like to apologize for the blunder. So please just note that the judges, if you heard that my affirmative speaker one had this distraction because of me, so please, my sincerest apologies. Please do acknowledge that she also went with the argument, even though there was some bit of distraction. So it's commendable. My sincerest apologies.
Your audio is clear.
Ma'am, can you hear me?
Yes, your audio is clear. Don't worry.
Oh, great. Oh, thank you, ma'am. Okay, thank you, ma'am. Okay. Firstly, I would like to acknowledge the submission made by my opponent team. However, we beg to differ. This is because it is crucial to understand and acknowledge that the investor state settled dispute has a fundamental and adversarial impact on the state's sovereignty. This is because under tribunal disputes, when a corporate interest is favored upon the state's interest on the basis that is linked with protection and the welfare of the state, has impeccably adversely affect the statutory and regulatory system. As such, it is crucial to notify that it questions the validity and the immunity of the state's sovereignty. To exemplify this notion, I would like to introduce a case of THIULDT versus the Government of Canada. In the case, it illustrates how corporate interest is favored by the state's interest when the policies were predominantly made for public health and environmental protection. In the case, ethyl crop was banned for producing a gasoline additive called MMT by the Canadian government. As such, they would bring the arbitration on the fact that they were in violation of the trade agreement, and specifically under the concept of expropriation, meaning the protection of expropriation, meaning that the state has to protect and take the property through compensation without any compensation whatsoever. As such, this has led us to the fact that under the tribunal decision, it explained that it went for the ethyl corporation, whereby the Canadian government had to compensate and at the same time had to reverse the statute that was banning the additive. As such, this just goes to show that international arbitration has the capacity to undermine the state's sovereignty, especially in cases whereby the statutes are made for environmental purposes and the welfare of the state. Thank you.
Thank you very much. For the second rebuttal in the against position, Masaryk University debate team, you have 2 minutes.
Thank you very much. So we argue that the state sovereignty is not endangered, but on the contrary, thanks to the document drafted by the UN Commission on Trade and Development, the international investment arbitration further strengthened the sovereignty of the state. One of the main contributions of the reform introduced by the UN Commission, the state was given a clause, denial of benefits, and as was already mentioned, this clause gives the state an opportunity to deny protection to entity or investment that are controlled by persons from countries with the party doesn't maintain diplomatic relations or which are subject to economic sanctions. Next significant reform is the explicit acknowledgement of the right to regulate. This right is used in case of protecting public interest. For example, it was used in the EU-Vietnam Investment Protection Agreement, and this reaffirms the state's right to regulate to achieve legitimate policy objectives such as the protection of public health, safety, environment, or public morals, and so on. And the last reform I would like to point out is public policy exceptions, which permit public policy measures otherwise inconsistent with the treaty to be taken under the specified circumstances. They foster coherence between international investment arbitrations and other public policy objectives and reduce states' exposure to claims arising from conflicts that might occur between the interests of foreign investors and the promotion and protection of legitimate public interest objectives. Thank you.
Thank you. We have now heard the rebuttals from both teams. Opening for the position in favor, for your concluding statements, you have 2 minutes.
Am I visible and audible?
Yes, you are.
Ladies and gentlemen, thank you all for your attention. As our team had affirmatively argued through analysis of cases with respect to BITs or bilateral investment treaties, we strongly contend that international arbitration does, in fact, undermine state sovereignty in favor of corporate interests in disputes for the following reasons. Firstly, fair and equitable treatment clauses are vague and open to the interpretation of the arbitrator. Secondly, how regulatory chill undermines a state's power to enact legislation for the benefit of its citizens. And thirdly, how expropriation can be invoked by corporations to favor their interests. As our first speaker highlighted on the vagueness of the fair and equitable treatment clauses, these create issues as arbitrators may select commercial affairs, over the state's public policy interests. This was highlighted in the cases of Crystal X versus Venezuela, Bilcon versus Canada, and Ethyl Corp versus Canada, where the arbitration tribunals had failed to consider arguments with respect to the nation's environment and community core values. Furthermore, regulatory chill deters nations from enacting legislation due to the fear of facing arbitral legal action. For instance, Uganda and Togo refrained from implementing health policies against smoking, apprehensive of potential costs and the protracted nature of legal proceedings threatened by Philip Morris, the tobacco company. Therefore, it is our conclusion that powerful corporations driven by profits impede and undermine the goodwill intention of states in protecting public health, culture, and the environment. This imbalance tilts the scales in favor of corporate interests in international arbitration. That is our submission. Thank you very much.
Thank you very much. To conclude the match, for the conclusion in the against position, Masaryk University debate team, you have 2 minutes.
Thank you for your attention. In conclusion, first, we want to say that state sovereignty remains clearly intact. They enter voluntarily, states choose arbitrators so they can choose experts. This system is supported by more than 150 countries, which clearly gives it credibility. And also, as we said already, the perception of sovereignty has changed. As for the examples the other side gave, for example, the Philip Morris case, we understand that in the past there were issues and there were problems with investment arbitration. However, as we argued, these problems are already fixed or are being fixed this very moment. Because as we already explained, UNCTAD, a United Nations organization, is helping countries renegotiate their treaties so that for example, fair and equitable treatment is no longer an issue. As we said, right to regulate, public policy exceptions, and denial of benefit clause, these all are new adoptions to these treaties. Another big thing is the example of Ecuador, a state which has left exit convention in 2009, probably for the reasons the other side explained, but then came back in 2021 when they adopted and renegotiated these new deals with countries, which means that yes, the problems were, but they are in the past. And also we want to point out that renegotiation of the existing deals takes as long as termination. So why should we destroy what we already have when we can simply recreate it? Thank you for attention.
Thank you very much, and congratulations on your debate. You can now relax. You will no longer be graded after this part. You can take a sip of water. We'll do a short feedback with all of you participating today, and after the students, also one of the coaches that is present for the match. If there is any feedback you would like to share with the students, that's also a time. So starting with the University of South Pacific, Ms. Lal, how did you find the debate? Was the topic perhaps something you're familiar already with from your studies?
No, actually, I've never done a topic related to either investment or international trade or international arbitration. So this was a very unique experience. Just getting to research and learn more about it has really broadened my horizons. And I'm definitely a lot more interested in international arbitration now. So it's, yeah, very exciting. Thank you.
Thank you for sharing. Ms. Balerikova, how did you find the debate? Is this topic perhaps familiar for you in your studies?
Well, firstly, the debate was excellent. My heart is pounding. The opposing team was marvelous, and I'm so proud of my colleague, who was excellent as well. So thank you, everyone. And the topic, yes, our dear teacher already introduced us with this topic during his course. So I was introduced to this topic already, but after the research, I'm more interested in this topic, and I think I will be carrying on my research.
Great, thank you for sharing. Mr. Permel, how did you find the debate? Was this topic perhaps also inspirational for your next steps in the studies or career?
Yeah, this topic especially was very interesting to me because we haven't learned about it in any capacity, so it was really fun learning the principles, the cases in relation to international arbitration. Credit to our coach, Ms. Gursova. She really guided us, given that this was a new topic for us. So thank you for our coach, and thank you to my colleagues as well for USP. They did an amazing job, and my colleagues from Masaryk University. It was wonderful meeting all of you, and your submissions were great as well. Thank you very much.
Thank you very much as well for sharing. Mr. Chura, how did you find the debate? Is there anything you would want to wish to the opposing team for their next steps in the debate?
Oh, well, the debate was amazing. I wish the best of luck. They were great. And the arguments they prepared were incredible. I already had some basic experience with this topic from previous course, but my knowledge deepened during this intense week. So it still broadened my horizons and gave me a lot of new informations. Thank you.
Thank you very much for sharing. Ms. Prakash, how did you find the debate? And is there anything you would want to wish the opposing team for the next steps in the debates?
Firstly, the topic itself, that was really new for us because we haven't learned the concept, as my colleague has explained. And upon like learning more about the international arbitration, its process and dynamics, it really did put an inspiration on me as well to like, there's so many fields that you can pursue on. So it was a very great learning experience. And I'm very privileged to also have counterpart colleagues to participate in this debate with them. So thank you so much for the lovely debate, and also my colleagues as well for the support and the hard work that we've been through. So it's a very, very fruitful journey.
Thank you very much. Professor Schwetz, is there anything you would like to share with the students as you have seen the debate?
Let me just say that FIJ University did excellent job. Congratulations. And in fact, this was our first match. So I'm very grateful for having my students their first real experience. You can watch a lot of YouTube videos of past year matches, but without your first real experience, it's very difficult to transfer how to address and what are the real feelings through the competition. I'm very proud of them. Let me say that I'm very proud of them, and after all, I do like the concept, and I do like that there are a lot of different, very niche topics of international law. International investment law is one of my favorite. So it was, and I'm very proud of my students because they did already have some basic understanding of international investment law, so it was a little bit easier. However, next time, who knows what are we going to address, and I can't wait for it. So good luck, FIJ, and see you in next round.
Well, thank you very much for sharing. Actually, the Masaryk University debate team, your match in round 1 was postponed. And really, thank you for being accommodating for the opposing team as well. So just for everyone to know, day 1 will be happening for the team in end of March, actually after the round 3. And for the round 3, actually, the topics will be focusing on technology and cyberspace. So perhaps another variable for everyone where you can use the concepts that you have learned in your studies and apply it to a new area of law. Well, the 3 judges will grade your match independently. They do not know each other. After the 2 business days have passed and we receive the scores, the organizing team validates the scores, shares the result via social media as well with the teams. You'll receive your scorecards, perhaps with the feedback or tips from the judges that they might wish to include as well for the teams. So really thank you all to the participants, to the coaches, but also very much to the judges for taking the time to review and share the expertise with the students. And for the final part of today's session, I would just like to highlight that you really are students from 2 universities in completely different parts of the world. So it's a good opportunity to stay connected. perhaps in your future careers, be that academic or in a more direct approach to law, perhaps in courtrooms, perhaps in international arbitration. It'll be always good to have colleagues across the world. So perhaps a little icebreaking question to start the communication between the teams a bit more. What would you like the other team to know if there would be just one thing that you would like them to know about your country or your university that you could share with us now? Perhaps starting with Mr. Permal.
Hello, everyone. Varun here from the University of the South Pacific. So interesting fact about university, it is spread out across 12 different countries. So it basically embodies the name University of the South Pacific as it is comprised of multiple South Pacific countries, 12. So yeah, thank you very much.
Thank you very much for sharing. Ms. Balerikova, what is it, the one thing that you would really want the other party to know for sure about your university or country?
Of course, our country is beautiful and worth of seeing, and our university is really special compared to other great universities with its informational system and great teachers that are great not only by their experiences and knowledges, but are also great by personalities, as they really care for their students.
Thank you for sharing. Ms. Lal, what would you say is the pathway to become a lawyer in Fiji? Or if that is something that you're looking into for your next steps?
Yep. So usually once you're done with high school, you would enter into an LLB or Bachelor of Laws degree, which is what the three of us are currently pursuing. This is a 4-year program. And once you've sort of gone through the system, you then have to do a post-diploma course, which is just preparing you for work placement and stuff. So that is for 6 months. And once you've completed that, then you're finally admitted to the bar and you can practice as a lawyer. Yeah, so that is the pathway. Thank you.
Thank you for sharing. Mr. Chura, what would you say is the pathway for you in Czech Republic, if that is something you're looking forward in your future?
Well, in Czech Republic, the system is a bit different because here, after high school, usually you have something like bachelor and then a PhD, and you can go on and on. But with law, it's specific that you have you go from nothing to, it's called magistrate. It's something between bachelor and between PhD. So you study for 5 years, and we are kicked in the ninth semester. You have nothing, so that's a bit funny. And when I will finish studying law, I may either choose the pathway of a judge or maybe a lawyer. I will see. And I just want to say what is special about university is that all the highest courts in our country are not in the capital city, but are in the second largest city. That's a tradition in many European countries, as well as Germany and I think Slovakia as well. That the highest courts are in a different city because so that it would stay independent from the politics. So all the courts are here, and the judges are sometimes visiting our university and giving courses because it's so close, or sometimes they are teaching here as professors or some other teachers. So yeah, that's what I wanted to say.
Well, thank you for sharing. And one final question, which I will address to Ms. Prakash, and then in general to the Moody team. You can choose which one of you would want to answer. So what would you say is a common stereotype about Fiji that might be true or that is actually quite untrue?
About Fiji. One of the common stereotype that I've heard generally that Fiji is a very friendly nation, which is true. They're very friendly, very open, very intriguing. And the perfect part about it is like it's a multiracial nation country. So with many race and given it's a University of South Pacific has a lot of regional students also coming in. So it's like filled with so much diversity, so much connectiveness, which is true about Fiji. I could attest to that fact. So yeah, that stereotypicism is true. It's very friendly.
Thank you for sharing. What would you say is the same answer for you in Czech Republic?
I think I may go. Well, Czechia, I would say, is a bit friendly, but I would say it's a friendly nation, but also it is some tradition, so not completely, I would say. And I would also say that there's a stereotype that Czechs enjoy drinking beer quite a lot. And I want to point out that it's true, and it's not as funny as it sounds, because we have a big drinking problem. And I think we are the highest drinkers of beer in all around the world. So yeah, the stereotype is true, but also the beer is very cheap. So and there's like thousands of brands. So if you ever come here, you can choose from many brands, and it's cheaper than almost anything. So yeah, and also I wanted to ask the other side. How hard is it to get into law in Fiji? Because it's a completely different culture, and so I just wanted to know.
If I may answer on behalf of our team. Yeah, in Fiji, it's pretty easy to get into law. We actually have a surplus of lawyers in Fiji. So what we have is graduated lawyers transitioning into other types of work. So in Fiji, it's pretty easy to become a lawyer. As soon as you get out of high school, you just need to have, out of 100, your English mark needs to be above 70%. And then, yeah, you're good to go as a lawyer, to study law, that is.
Well, thank you everyone for sharing and for a very good interaction, and for, again, congratulations on your day 2 match in the competition. You now have few days to wait for your results. With how close the round 3 is actually happening, you might get your results actually later than the topic for the next round. If that happens, we'll try to rush as much as possible to get the results to you, of course. Yeah, that would be all from the organizing side. If you wish to stay in contact via email, do not hesitate to let us know. We are happy to connect the 2 teams. Of course, we also tag everyone on LinkedIn when your teams are announced or when your matches are announced. So that's also a way the students can stay in touch. Well, once again, congratulations, and wishing you a successful end to the week.
Thank you.
Thank you, everyone.
Thank you.
Thank you.
Thank you very much. Goodbye.
Bye-bye.
Bye.
All the best.